Call the next case, please.
Chattanooga-Hamilton County Hospital Authority doing business as Erlanger Health System versus UnitedHealthcare Plan of the River Valley Incorporated doing business as AmeriChoice.
Good afternoon.
Good afternoon, Your Honor. My name is Steve Riley, and along with my partner, Greg Reynolds, we represent the Erlanger Hospitals. I'd like to reserve 4 minutes for
4 minutes, yes, sir.
Thank you. This appeal is about whether an insurance company can avoid paying fair value for post-stabilization services it approved and was paid by the state to provide for hundreds of its insureds over a 5-year period. AmeriChoice recently claimed that it was not obligated to pay Erlanger that fair value because, it says, Erlanger did not tell it in some special way that its enrollees were stabilized. AmeriChoice says that under a regulation which is incorporated into its TennCare contract, that it is not responsible unless it gets some special notice that the treating physician had determined that its enrollees was stable for transfer.
Do you agree that the type of notice is the single issue in this case?
I think there are two issues. I think there's an issue of law, whether there's notice required at all, and secondly, if there is, whether they got notice and whether we have a genuine issue of material fact.
That's fair. Okay, thank you.
The lower court agreed with AmeriChoice and mistakenly held that the regulation at issue required Erlanger to provide some special notice of stabilization before AmeriChoice's pre-approval of the care would count, and mistakenly granted partial summary judgment on that basis. The regulation does not say that. And even if notice were required, the lower court erroneously held that AmeriChoice did not have notice. The record is replete, we argue and submit, on which the jury could find that AmeriChoice had the notice that its patients were stable. Finally, notice is not an element of unjust enrichment. There are 3 elements, and Erlanger presented proof on each of those 3, and we think the court erred in taking that claim away from the jury. Turning to the regulation, the Chancery Court inferred a requirement of notice of stabilization from 2 separate subparts of a regulation, 42 CFR 422-113, which is incorporated into its agreement with TennCare. What does the regulation actually say? First, subpart C2, which is the part that deals with post-stabilization care, which is what we're dealing with here, simply provides that a managed care organization, MCO we call them, is financially responsible for post-stabilization care when the care is pre-approved. That requirement was met here in every one of the cases we're pursuing. AmeriChoice approved all 1,371.
And that process was via this admissions fax, is that correct?
No, it was more than that, Your Honor. What Erlanger sent AmeriChoice was a so-called admissions fax, which said, here's your patient, they're in the hospital, here's the treating physician, here's her telephone number. If you want to transfer them, we'll help you. If not, we're going to provide them with this care, appropriate health care services, and we expect you to pay for it. And you can either agree with us on paying for it, or we'll litigate that issue. So it was more than just an admission fax. And
Okay,
I think
so that was the admissions fax, but was there some other mechanism this pre-approval was solved then?
well, with that admissions fax, the medical records were provided.
Yeah, I mean, I guess what I want to try to focus on is in every instance here we're dealing with, there was always this this admission fax component of it.
Which was a cover letter to the medical records.
Okay, right. And was this always, I get the impression reading the briefs that perhaps the admissions fax sometimes came after the service was rendered. Is that correct?
It was done as promptly as possible. So Was service held up for a patient? No. So for example, in our case that we cite as an example, Ron would nickname that for privacy. He was admitted late in the night with a broken ankle. At 7 o'clock the next morning, when he had been admitted to Erlanger, after being transferred from the network, two things were sent. This notice, admissions fax, we've got your patient, and here's medical records, which those medical records detail, in fact, in this case, the treating physician expressly said he's stable and detailed the orders for what the treating physician was going to provide in terms of post-stabilization services. So AmeriChoice had all of that as of about 7:30 that morning. And later in the day, they approved it, gave an approval number, and there was a discussion in the record. It's on the flash drive. The medical records are, because they're under seal. There was a discussion, and it was approved. They said, we'll approve you for 2 days, and then you come back and get additional approval. And that occurred. Erlanger complied, sent them additional records, and it was approved again. In fact, they improved all of the care. Now, what they didn't do is they paid at rates, we don't really know what they are, but they were not rates that were agreeable for post-stabilization services. And the litigation occurred some 6 months into that out-of-network period.
Would you agree with the proposition that a patient could be admitted to the hospital and it be not post-stabilization care? In other words, it's still emergent care?
Yes.
Okay.
And in that case, that could happen, and a couple of things could happen if it was not post-stabilization care. AmeriChoice could deny it. They had every right to deny it. In fact, it was their duty under the contract with TennCare to inform themselves of that. And so they could deny it. They could call the treating physician and say, is the patient stable now? We know all patients at some point prior to discharge, unless they expire, are stable. So the patient was going to be stable at some point. And they could call under their obligation that they created for themselves, and TennCare created for them in their contract. And I hope you're familiar with that, because in the TennCare contract it says you AmeriChoice must establish a procedure by which you will determine whether the patient is stable for transfer. Well, they did that. They set up that procedure. We took the deposition of their chief medical officer, and he said, yes, my physicians that worked for AmeriChoice had the duty to contact the treating physician to confirm and document stability before deciding whether to approve the care. Erlanger was aware of that obligation. It was a public record that it's in the risk management agreement. And sometimes they did that, sometimes they did not. But they did approve everyone that we have.
And are you referring to that process in the 2.14.1.9.1-3 there, number 1? Is that the pre-admission certification process?
It's at 2.1419.2. 2,
okay.
Yes.
Not 1.
Correct. It's at the record 8, appellate record 8/1153. It says, contractor shall have a process in place to determine for emergency admissions based upon medical criteria if and when a member can be transferred to a network, to a contract facility. And in the record at 30:44:16, Dr. Hollis, their chief medical director, says, yes, that means that we call the attending and document the stability or lack thereof of the patient. And it was tasked to them. And he confirmed that in his deposition again at volume 30:43:67.
Let me ask you, when you say they approved the care in all of these cases, are you talking about in all 1,300 cases? they approved?
1,371. There are about 250 that they denied care, and we're not pursuing those at this time.
Okay, and how did they indicate approval of the post-stabilization care?
They would call us, call the hospital, and say, here's your authorization number. The care is improved. So there's a whole set of records, and Ron is an example of what happened in every case.
And Ron is one of the 1,300 cases that we're dealing with today.
Yes, he is, and we just used one as an example
Right.
because the process occurred in every one. But with respect to Ron, the nurse at Erlanger and the nurse at AmeriChoice, and for a time there was a nurse stationed at Erlanger that was employed by AmeriChoice, would confer, and approval was given and noted and documented by Erlanger in its records. And we now know by discovery it was documented in AmeriChoice's records. And they paid something. They just paid a pittance of what
But we aren't dealing with what they should have paid. We're just dealing with the question of whether or not they authorized the post-stabilization care today, right?
I think that's right. There'll be a trial, I hope, on what they should have paid. But the point about the fact that they paid showed that there was a concession, that they knew the patient was in the hospital, was receiving services, and they just disagreed on how much they were going to pay for them.
Okay.
I think I'm about out of time, so I'm going to just jump quickly to say that even if there was some kind of notice of stabilization due, when you look at Ron as an example, there was a plethora of evidence in which a jury could determine, they knew. And Tennessee case law is clear on that, because notice under Tennessee case law is knowledge of facts and circumstances sufficiently pertinent in character to enable reasonably cautious and prudent persons to investigate and ascertain the ultimate facts. That's a jury question. And so if they're going to dispute that, which I don't think they will ultimately, but if they're going to dispute that, that is a jury issue. And so it is, I believe I'm out of time, but it's for all those reasons that we believe the Chancery Court erred both on the issue of law and on taking the case away from the jury, and we ask that it be remanded for trial.
Thank you, Mr. Riley. We'll hear from you on rebuttal.
Thank you, sir.
Good afternoon.
Good afternoon, Your Honors. Bill Jordan, representing UnitedHealthcare of the River Valley, doing business as AmeriChoice. With me is my colleague, Rachel Leff. Let me start with what Mr. Riley indicated, which is that there was, in fact, record evidence of stabilization determination for each of the 1,300 or so patients at issue here. It is not there. Their expert so testified in his deposition testimony. He said, and was asked, do you recall seeing instances where Erlanger or its physicians notified AmeriChoice that a patient was stable or could be transferred? Not only can I not recall that, that is not something a physician would do. Yet that is exactly what the governing regulation here requires. It requires unambiguously that the treating physician make the determination. In fact, it's not even discretionary. It says that the treating physician must make a determination that the patient is stabilized, and that then tees off the notification requirement, the request to be made to the payer for the transfer or the approval of the patient.
Why doesn't the admissions facts do that? I mean, that initial paragraph to me seems like it's inviting your client to transfer this patient or potentially transfer this patient. To me, doesn't necessarily follow from that the patient is stable enough to be transferred. I mean, it says, if you would like the patient transferred, please contact the patient's PCP.
I'm sorry, I didn't mean to interrupt you, Your Honor. Two reasons for that, Your Honor. Number one is their 30B6 witness, Mr. Stephen Johnson, the head of their payer relations department, testified unambiguously that that fax was not meant to convey anything about stabilization. He was asked that and said that as the corporate designee.
What did he say the purpose of the fax was?
He said it was to notify that a patient had been admitted from the emergency department into inpatient. And that does in fact trigger an obligation on the managed care organization under the CRA to start the process of looking at the care management for that particular patient, which is exactly what AmeriChoice did, in that it did not know and would have no reason to know until such time as the treating physician makes the determination, and then that triggers an obligation to make a request for pre-approval of the services. And in fact, Judge, Mr. Riley cited to patient Ron. Patient Ron is in fact informative of the lack of the determination by the treating physician and the lack of the request for pre-approval. When one looks at the records that Erlanger filed in this matter related to patient Ron was in fact in the emergency department, admitted to inpatient and put into surgery at the time that the records were filed. There could have been no request for pre-approval of a service. It deprived AmeriChoice of the option to pre-approve a service because he was already in surgery.
Well,
Yeah.
you don't need pre-approval for emergency service, do you?
Yeah, you absolutely do not need pre-approval for emergency surgery. That is correct, Judge. And that is the assumption that until such time as the treating physician has made that determination of stability, that the services are pre-stabilization services. That's what the regulation would require. The Desert Valley case that we submitted is instructive. It's the Medicare Appeals Council, the Departmental Appeals Board, which went through a very similar circumstance, very similar argument to that being made by Erlanger in this case. And it says that the decision by the treating physician triggers the emergency provider's obligation to notify the managed care organization. It then goes on to state that mere notations in the record, patient Ron is a good example of that. There was a checkbox on a surgery admissions form, since he was already in surgery, that said he was stable for surgery. That record was in fact, as it showed, sent to AmeriChoice, but all that is a documentation that he's stable for surgery. He certainly can't be transferred while he is in the operating room, and there was no determination that he was stable for transfer. The Desert Valley case goes on. It says, mere notations that appear in the medical record that an enrollee was stable, they're not a substitute for an explicit decision by the treating physician as to when the enrollee may be considered stabilized for transfer and discharge, nor does mere contact by the hospital, Desert Valley in this case, with the managed care organization substitute for documentation of the treating physician's decision. And when one looks at the regulation actually sets up a very orderly process where that request for pre-approval is triggered. The treating physician makes the determination that the patient is stable for transfer. There then is a very accelerated process. In fact, it requires that there be that notification, the request for pre-approval. The regs actually say, the commentary to the regs actually say one would expect it to be made in 1 hour. And then there is a 1 hour time requirement that is put on the managed care organization once it has the request for pre-approval and the notification of stabilization for it to make a determination, or else the reg actually says the managed care organization becomes responsible for the care. That did not occur in these cases. There is not any record evidence that there is documentation by the treating physician of stability that was sent to AmeriChoice, and that AmeriChoice then pre-approved any care following receipt of that request for pre-approval.
Let me propose a hypothetical to you and see how this works in the way that you conceive the way that the regulation or the risk agreement should be read. Let's say the treating physician said, this patient's definitely not stable, but through some clerical error, the hospital sends off a notice and says, patient stable, we want pre-approval. In that circumstance, would the MCO be responsible for post-stabilization care?
Let me see if I can repeat that back and make sure I have your hypothetical correct, Your Honor. That is, there was a mistake that there was in fact a request for pre-approval and
properly made.
But in fact the patient was not
stabilized.
stabilized.
Either the physician affirmatively determined that, or didn't make the determination at all, and the request was made, would it be payable in that case as post-stabilization care?
Here is, so I think under the regulation, let's assume the mistake that, the treating physician had not made it, but there had been a communication and a request for pre-approval, and then there was that pre-approval. I actually think in that case, the regulation would probably say that there had been pre-approval of that post-stabilization care.
That would go through okay then.
The question in my mind, one has to recognize the complications for a submission of a bill for payment as to what it would then look like, because it could have been submitted under an emergent code or something like that. So that would be my only qualification with that hypothetical.
Okay, I'm just trying to think about what we might decide here today might play out in the real world, because it seems like to me that there's some bit of that the way that the regulation is set up and the way the risk agreement is written doesn't seem to meet the reality of care, but perhaps, completely misapprehend the way this thing is supposed to work. It seems like 24/7, the hospital is supposed to be monitoring this patient, and the moment of stabilization, the MCO is saying, you need to fire off a fax or whatever communication right there within the hour that says patient stable, and whatever additional services we want to render you need to pre-approve it, and we're going to respond within the hour 24/7. That's the way it's supposed to work.
That is in fact the way it is supposed to work. And the regulation also recognizes that there could be delays, right? So once that notification is made, if for whatever reason the managed care organization didn't have someone working overnight, or for whatever reason, that financial responsibility does in fact fall on the managed care organization. But it does set up this very tight process because we're involving patients here, Judge, right? The patients are going to they may need to go in for elective surgery into the operating room. They may need to have other types of care. And so it does set forth a very speedy process that must be followed with respect to these out-of-network payments. And in fact, the regulations in Tennessee actually set forth that it says this is 1200-13-1308-1C. Any non-participating provider, such as Erlanger, as defined in this chapter, who provides a TennCare program covered non-emergency services to a TennCare enrollee without authorization from the enrollee's managed care organization, does so at his own risk. And so it does set up admittedly, these very tight processes. And there are examples where the processes were followed appropriately. We talked about a patient in the lower court named TS, and he ultimately ended up getting transferred. But that is in fact what the regulation requires. And what Erlanger is offering to the court is a situation where they did not follow the requirements in order to have the treating physician make the determination, in order to give AmeriChoice the opportunity to pre-approve the service or to determine whether the patient needed to be transferred. There was, in fact, an authorization that my colleague, Mr. Riley, did tell you. There was an authorization number that was provided, but that authorization was not for post-stabilization care because it couldn't be by definition, because there had been no request for post-stabilization care.
Let me ask you, under this process, isn't it commonplace that the request would be made by a telephone call from a hospital representative to an MCO representative, and there's no written documentation required?
That is correct. There is no set requirement for what form that request must take, but the request must be made. It could be done by telephone call, it could be done by fax, it could be done by email, it could be done by any means, but there must in fact be a request.
Yeah. Well, what would make, since you don't even have to have written documentation, what would make the fax defective? Because the fax is clearly saying, we treated your enrollee for emergent care, and now they're being admitted into the hospital, and emergency room somehow is different from an admission into the hospital. Why isn't that enough to advise you that now they've been stabilized and they could go into a room? And actually, under Malta, if you treat someone at an out-of-network facility, and even after you deal with them in the emergency room, if they've not been stabilized and they have to go into a room, that out-of-network hospital is still entitled to be paid for their care. Isn't that true?
That is entirely correct, and they were paid for the Erlanger has been paid for the care. They do not agree with the rate at which they were paid for the care.
Well, we aren't really dealing with rates today, right?
Correct, and you're absolutely right, that under EMTALA, there is a stabilization, essentially a stabilization or record-keeping requirement in EMTALA so that those EMTALA obligations end. The Desert Valley case dealt, I think, Your Honor, with the scenario that you were just speaking of. It said that in that case, the administrative law judge concluded that because the enrollee had been transferred from the emergency department into inpatient status, that transfer was an indication that the enrollee's medical conditions had stabilized. However, the Secretary's rulemaking only provides limited instances in which an inpatient admission is, by itself, deemed to represent a patient stabilization. And so that admission into inpatient is not talismanic, because you still have to have, under the regulations, and even for certain EMTALA requirements, that determination of stabilization in the record, documented and transmitted to AmeriChoice, so that it can then go through the process of saying, oh, should this patient remain at Erlanger, or should it be transferred to another facility? In my last minute, judges, I would like to just note that we did file a motion to dismiss on jurisdictional grounds. We do not believe that under the standards of 5402 that this certainly doesn't resolve claims against a party, nor does it resolve a cause of action. In this case, there are certainly claims, and that a claim for payment is a claim, but that is different than a claim that is a cause of action. In this case, we are dealing with a subset of 31,000 patients, and then 3,000 of those patients, Erlanger has indicated, were post-stabilization patients. Those have been treated the same for the discovery purposes. They involve the same witnesses, the same facts, the same documents. They, of course, each involve different medical records.
Well, true, but what about the fact that the subset that we're dealing with here on this appeal were all TennCare enrollees versus post hoc enrollees? I mean, isn't that an aggregate, part of the aggregate set of facts that makes this claim different?
It makes them different because of the way the 422.113 regulation would apply to them. It does not make it different from the standpoint of whether the records themselves, the governing TennCare CRA agreement, under which there is an obligation to pay for certain patients. The same witnesses are involved. The same, and these have been treated essentially the same for discovery purposes, but yes, for those who are what we were calling the non-retroactive enrollees, that is AmeriChoice members, there is a legal basis in that a different regulation applies to those individuals, but the underlying circumstances and in fact their cause of action has been the same throughout the entire length of this case.
All right, thank you
Thank you, Your Honor.
very much, Mr. Jordan. Mr. Riley, your rebuttal.
What you didn't hear Mr. Jordan say anything about was AmeriChoice's obligation, required by its contract with TennCare, to have a process to determine whether the patient was stable. He said that it started a process for them to manage the care. Well, that's exactly what TennCare said management of your care is part of. And their chief medical officer testified in no uncertain terms that it was their job to contact the treating physician if they wanted to know more than was in the medical records. And with Ron, they wouldn't, because the treating physician had already explicitly said he was stable, not stable for surgery, check the box, stable. If they wanted to know more, it was their job to call them, and Erlanger knew that that was their job. According to AmeriChoice's argument, it doesn't matter if AmeriChoice actually knew that the medical record or a call with the treating physician or a call with URNOS that the patient was actually stable. All that matters is they got some kind of a notice, a form that nobody in reality has ever seen.
Yeah, well, right, but, I mean, but the regulation says what the regulation says, and it says pre-approval. And so, I mean, so what if the MCO knows the patient is actually stable? If they don't get the pre-approval request, you know.
There's no I'm sorry.
Oh, yeah, please.
There's no dispute that they got a request for pre-approval in every case. There's no dispute about that.
And that's the admissions.
Admissions facts with the records, yes. What they say is, hey, you didn't push this secret button we've got, and that is we have to have a certification from the treating physician. And they go to B3 regulation, and they say, that's what that a physician must determine. Now, what Mr. Jordan said, he said must determine if it's stable. What the regulation says, in fact, is must determine whether this patient is stable before transfer or discharge. And those circumstances aren't here. Erlanger was not requesting a transfer. Erlanger was requesting approval of post-stabilization services. And I think it's important because nowhere in these regulations is there a duty on the hospital to do anything. And in fact, I think at pages 11 and 12 of our reply brief, we detail this. CMS was asked about this, and they specifically twice declined to put a requirement in these rules that the hospital provide some kind of notification. Now, on your reality point, I think the Desert Valley and Kaiser cases are important because what those cases said, we have a situation where in one case, at a certain time, a doctor said this patient's not stable for transfer or discharge. Other times, the physician didn't speak. And the Medicare Appeals Board in that case said that's when you look to the facts, and the administrative law judge must determine and adjudicate the facts on the records and see whether in fact the patient was stable. So this was a duty of AmeriChoice to determine. Erlanger gave it everything it needed to facilitate that determination. And what did it do? It could have just denied. It had a discretion to just deny, and there would have been an administrative argument about that. Instead, what they did is they approved, and they approved it for 5 years.
Well, let me ask you about this, because you did not pick up on the reply brief, and I was curious about that. In AmeriChoice's brief, they cite to another provision of the contract, and it's one paragraph below what we were talking about earlier, and that's 2.14.1.9.3, admission review for urgent or emergency admissions. I mean, why wouldn't AmeriChoice be justified in thinking, well, that's what this is all about here. This came in as an emergency situation. They are asking for further review of an urgent or emergency admission here.
Well, if AmeriChoice thought that this was a situation where this continued to be emergency care, they could deny.
Well, they could, but,
And I don't think there's any question that they knew that what we were requesting. The question is they just disagreed that they had an obligation to act because they didn't have this special notice. And the trial court agreed. And there's nothing in the regulations that require hospitals to do that. That burden was on them.
Mr. Raleigh, is that because the treating physician in all of these cases is not an employee of the hospital, is he or she?
They are not typically, Your Honor, they are not employees of the hospital. They make independent judgments about patient care. They may be in network with AmeriChoice, but they are typically not an employee of the hospital. It's not somebody the hospital can direct what to do.
All right, okay.
All right, thank you,
Thank
Mr.
you.
Riley. Thank you, Mr. Jordan. We'll take this matter under advisement.